The pleasures of being an alumni volunteer is you get to meet great alums, both as people as well as authorities in various fields and interests. Bill Josephson graduated from the college in 1952 and from Columbia Law School in 1955. He was a founding counsel of the Peace Corps, drafting the March 1st, 1961 executive order that celebrated its 60th birthday yesterday. Bill was retained by the Democratic National Committee to work on Electoral College issues in 1980 when the committee was concerned about the third-party candidacy of John Anderson. He was subsequently consulted with respect to the interventions of Ross Perot and Ralph Nader. Out of his work came a series of law review articles which have been widely cited, with Beverly Ross Campbell, Repairing the Electoral College, and the Electoral College and the Popular Vote. He has more recently authored Senate Election of the Vice President and House Election of the President, dealing with the contingency provisions in the 12th Amendment in case no candidate wins an absolute majority of electoral votes. His current articles are The Myth of National Popular Vote, Presidential Elections, and the Reality of Electoral Unit Rule Voting, and Chiafalo versus Washington State, Justice Elena Kagan's opinion that states may bind presidential electors to cast their ballots for the winners of their popular presidential elections raises many issues. Bill taught for 3 years at the University of Chicago's Institute of Politics with Steve Edwards, was then its deputy director, where he oversaw all programming and operations, including the X-Files podcast, David Axelrod's periodic venture into mass media. Steve's professional career spans over 20 years as an award-winning journalist, producer, and program host, as well as chief content officer at Chicago's WBEZ. So I ask everyone to please welcome Bill and Steve in the conversation. Thank you.
Thank you, Reggie. Hello, Steve.
Bill, it is great to be with you. Reggie and Bill and Natalia, thank you so much for creating this occasion for us to have a robust conversation about the Electoral College, which has been ever present in as a focus of attention for us in recent weeks and months, and with a long, rich history, obviously, that we'll delve into as well. Bill, you and I had a pleasure of getting to know each other on campus at the Institute of Politics, having conversations like this related mostly to public service and the history of the Peace Corps as part of the Sergeant Shriver program in public service leadership, which was wonderful. And it's nice to be back with you tonight. So how are you?
It's wonderful to be with you, Steve. We've been apart too long and we need to more often.
Yeah. Well, we want to involve other folks in the conversation tonight to be back as part of the University of Chicago community. We know that there are many alums and other members of the community. So we'll take your questions. Bill certainly will take your questions as we go forward. We ask at the bottom of your screen, you'll notice, for those of you who are less familiar with Zoom, there is a chat function, and you can click on the chat, and we ask that you put your question into the chat as we go, and we'll do our best to get to as many of your questions as possible. We're going to spend a little bit of time at the beginning just putting some context around the Electoral College, and then about a half hour, 40 minutes into the conversation, we'll open it up to your questions as well. So, Bill, let me begin just by having you give us some important historical context. Take us all the way back to the origins of the Electoral College, to the Constitutional Convention of 1787. How did the Electoral College come to be a facet, not just of the Constitution, but of presidential election life today?
Thank you, Steve. My wife suggests that I start out a little bit differently from what you and I originally discussed. She suggests that I make it clear that I am not a defender or attacker of the Electoral College. I am an analyzer and an explainer, and trying to get people to have a better understanding of why it's there, and unfortunately or fortunately, why it probably always will be there. So hark back, if you will, to the very hot summer of 1787 in Philadelphia, with touches of malaria and yellow fever in the air. The 55 delegates who originally assembled, and not all of them were there all the time. For example, Hamilton was virtually never there. And some of them were there all the time. James Madison, for example, was there all the time. And he is a key figure here. He prepared carefully for the convention. He read voluminously about other structures of government. And he also kept an indispensable running transcript of what happened in the convention, Madison's Notes, which is the most important of many sources of what happened at the convention at the day by day. The two issues that I want you to keep in mind start out really, the first starts out having virtually nothing to do with the Electoral College except indirectly. The delegates that assembled were not the patriots who signed the Declaration of Independence. Some of them were there, but most of them were not. These were lawyers and politicians and businessmen. They were preoccupied initially from May until July with the question of how to deal with the national debt that had been occurred during the Revolutionary War and by the Articles of Confederation, and for which provision hadn't been made. They finally achieved a solution of that on July 12 in a resolution which did two very important things. They decided that revenues would be apportioned among the states on the basis of population, and as determined by the census, which they decided which would take place every 10 years. And they decided there would be a House of Representatives similarly apportioned among the states on the basis of population as determined by the census and readjusted every 10 years. These decisions went hand in hand, as did, for example, the constitutional provision that revenue bills had to originate in the House. The other major issue which preoccupied them from time to time for the entire rest of the convention until the opening days of September, and which remained unresolved until then, was how to elect the President of the United States. They were agreed that that person should be a unit person, one person, but they were not agreed as to whether or not that person should be determined by some sort of parliamentary system, complicated by the later arrival of the Senate, apportioned among the states on an equal basis with 2 senators from each state, or should be elected by the popular vote or by some other means. 3 committees were established at the end of the convention to try to deal with this issue. 2 of them failed. The third one came up with the notion that the states themselves should elect the president through electors that would be elected by the state legislatures. That was the original formulation. The state legislatures would elect the electors. And the electors, they thought originally, would meet actually as a group until they discarded that as impractical and exercised their discretion to determine who should be president and vice president. And in the early days, no distinction was made in terms of slates and political parties. The original Constitution provided that whoever got the most elector votes would be president, and whoever got the next most elector votes would be vice president. And that's how Washington became to be president and John Adams became vice president. But very quickly, partisan politics entered into the situation to the extent that in the election of 1800, Jefferson and Burr tied, and the election was thrown into the House, which could not resolve the issue through many ballots. The result was the 12th Amendment, which separated the offices of president and vice president and really laid the basis for presidential and vice presidential slates, the same basis that we have now. So that, in a nutshell, Steve, is how we got to where we are.
And one of the key issues that has been a focus of attention in particular has been the question of so-called faithless electors. It was the focus of Supreme Court case, two Supreme Court cases combined into one earlier this past year, and historical debate and ongoing public policy debate over how states and electors, and indeed our entire election apparatus, should handle this question. So when you say faithless electors, what are we talking about?
Well, there's been an evolution of that through the 19th century and into the 20th. Jefferson suggested that the electors actually should vote unanimously, that would increase the power and influence of each state in the presidential election. And over the 19th century, gradually, to the point where when we began working on these issues in 1980, 26 states chose to bind their electors to vote in accordance in various ways with the political parties that selected them and to vote unanimously. On the other hand, it is still true that depending on how you count it, only 30 or 31 or 32 or perhaps 33 states choose to bind their electors, and they do so in very different ways. And nevertheless, nearly 20 states still grant electors the discretion to vote as they choose, and they have somewhat less than 200 elector votes, but that's still a very substantial number.
What are the challenges of that disparate approach and that patchwork approach, if you call it, to whether electors should be bound to the popular vote by a state present for the system as a whole as you look at it?
Well, I think the trigger here was what happened in the 2016 election, where 7 electors, and I dislike the phrase faithless electors because actually the 7 are doing what the framers certainly thought they should be doing. 7 electors chose not to vote for either Secretary Clinton or Donald J. Trump. And that gave rise to the 2 cases, Guerra against Washington State, which Washington State was a binding state, and Guerra chose not to vote for Hillary Clinton and was fined $1,000 and appealed. Baca in Colorado chose also not to vote for Hillary Clinton. And the 2 opinions, the 10th Circuit opinion in Baca and the Washington State Court opinion, could not have been more different. The Washington State Court opinion was cursory, and you wouldn't even think that the judge who wrote it thought she was dealing with a major constitutional issue. On the other hand, the 10th Circuit opinion in Baca, Judge McHugh wrote a long, scholarly, thoughtful opinion. In Washington State, the binding nature of the elector was upheld, and in Colorado, in the Baca case, Judge McHugh held that the elector had discretion, and the Supreme Court took both cases to resolve this serious split among the justices who considered the issue.
And from your perspective and the perspective of others, why were these cases so significant as it related to the future of the Electoral College and its operations?
They were significant because, first of all, they arose in a context of an election which everyone anticipated would be an exceedingly difficult and controversial election. And they were also significant because it provided the court with an opportunity to resolve an issue that it had left unresolved from a decision called Ray against Blair many, many, many years ago. And the fact that this issue of whether electors could be bound or not bound remained unresolved after, more than 200 years of a history of presidential elections was certainly a question that posed very, very grave consequences for our democracy.
In the writing for the majority, it was a unanimous decision in Chiafalo versus Washington. Justice Kagan wrote the majority opinion, and you have been critical of the argument that really was used to support the opinion that states could be allowed to, in fact, bind their electors. What is it that she wrote, and what is it that you find problematic about that state of affairs, both legally and as a practical matter for our politics?
I agree with the result.
Yes, yes.
That's very important. And I think the court was extremely motivated by the consciousness that the election it was confronting was not going to be a simple or an easy one. And it did not want to inject into that electoral turmoil yet another factor of extraordinary uncertainty. It wanted to settle once and for all that the states could bind electors if they choose to do so, and to remove that degree of uncertainty from the forthcoming election. And Justice Kagan's opinion certainly does that. She says things in the opinion that bother me a lot. She says there's no historical warrant for elector discretion. Well, that's absurd, and she knows that's absurd. She did not deal with certain subtleties that Justice Thomas points out in his concurrence. Why, from where in the Constitution do the states derive the power to bind or the power to remove if the electors don't behave? The Constitution simply says, as Justice Thomas points out, that the state legislatures shall appoint the electors by whatever means they choose. And indeed, early on, the state legislatures did appoint the electors, and popular election of electors, actually a late 19th century development. But Justice Thomas is right when he says that by implication, Justice Kagan is wrong to imply from the power to appoint a power to disappoint. He says when the Constitution is silent, as it is specifically on this issue, we look to other provisions of the Constitution, like the reservation of powers to the states. And he latches on to the amendment that reserves powers to the states as the source of state authority to bind their electors if they choose to do so. And I think, that's a creative and interesting solution to a problem, and a more satisfactory one than implying a power to disappoint from a power to appoint.
This piece is so essential for a deeper conversation because it strikes at the heart of this question of the popular will and an understanding by many culturally that, if not politically, and a push for some over many decades to expand enfranchisement and to actually create a process by which there would be the direct election of the President of the United States. And I want to talk more about those efforts in a bit. But on this notion of the criticism, Will Howell, who's a professor of political science at the University of Chicago, and has spent a lot of time looking at the Constitution and the challenges in a modern democracy that certain constitutional provisions allow, says that, around the world, the Constitution has been adapted and adopted by many, many other governments over time. The one thing they haven't adapted and adopted is the Electoral College. And more recently, former Obama speechwriter David Litt in Time magazine wrote, "The Electoral College, in other words, serves no useful purpose other than to intermittently and randomly override the people's will. It's the appendix of our body politic. Most of the time we don't notice it, and then every so often it flares up and nearly kills us." So what do you say about this inherent debate and tension and concern about the Electoral College in its structure and working against the popular will?
Well, I say two things. First of all, the attackers of the Electoral College rarely mention the fact that a 2/3 vote of the House of Representatives and a 2/3 vote of the Senate and a 3/4 vote of all the states would be required to adopt a constitutional amendment that would eliminate the Electoral College in favor of popular election of the president and vice president. I've looked very carefully recently at the Senate debate in 1970 on Senator Birch Bayh's constitutional amendment to do exactly that, which did in fact pass the House by a 2/3 vote, but which could not summon sufficient votes to close debate in the Senate on 2 cloture votes. And the analysis of those 2 cloture votes is quite interesting. The Southern senators themselves and the border state senators that might have been sympathetic to them could not themselves muster more than 19 Senate votes to keep debate open. They were joined by 17 Republicans. And those 17 Republicans were virtually a roadmap to those conservative Republican presidential candidates who have managed to get themselves elected to the presidency in the late 20th, early 21st century. That they were Midwesterners, small states with exceptions, Ohio, for example. And the other thing that's striking about the Senate then and the Senate now is that it was a much more liberal Senate in 1970 than it is today. You had Southern senators like Ralph Yarborough of Texas who voted to close debate. They don't exist anymore. The Senate today is a much more conservative Senate, in my judgment, politically, than it was then. And the chances of a popular vote constitutional amendment passing the Senate, even by a majority, I think, is scant, let alone by a 2/3 vote. And so the notion of realism, political realism, has to be injected into this debate, which the attackers and the defenders rarely inject.
There is another effort underway known as the National Popular Vote Interstate Compact, where 15 states thus far in the District of Columbia have signed on to a compact that would pledge to put their electoral votes behind whichever candidate actually wins the national popular vote. And some say that if you could get enough states to equal 270, that essentially it would be an end run around a constitutional amendment process to eliminate the practical impact of the Electoral College. I'm interested in your thoughts on the realistic possibilities of that, but also let me fold in a question from Bob Harrison, who says, would that effort actually be upheld in Supreme Court if in fact it succeeded?
I think the Supreme Court is bound by the Constitution. So if one were successful in getting adopted a constitutional amendment that provided for popular election of the president and the vice president, the court would abide by that. The other question that you're asking, national popular vote won't work for some 16 or 17 reasons, which I've set forth at some length in various articles. And I won't go into all of the 16 or 17 reasons because we would be bored to death and we wouldn't have the time. But in a nutshell, it would require all of the states who join national popular vote to be binding states. And a striking thing that many commentators about national popular vote haven't noticed is that many of the states that purport to join national popular vote are not binding states. Illinois, for example, New York, New Jersey, these are not small states. So those states that have joined have also largely failed to implement national popular vote in a way that is required by the Electoral Count Act of 1887. So their commitment to national popular vote is superficial and in fact not enforceable in any meaningful sense. And finally, it's a little hard for me to believe, particularly in these days of Donald Trump, that electors whose popular vote for their states did not accord with the national popular vote would nevertheless vote for the popular vote winner rather than the popular vote winner of their states as national popular vote would require them to be. And I think that's just politically unrealistic.
Yeah. We've been talking about some of the challenges, realistic and otherwise, with the national popular vote effort. Let's flip it. You have also been critical of the Electoral College, and we won't go through all of the many reforms that you and others have recommended, but fundamentally, go ahead, Bill.
Let us not do that.
No, but just at a broad level, at a conceptual level, what are the elements of the Electoral College that need to be shored up, if any? If you beyond going into, I think you had maybe 14 recommendations for reforms, but conceptually, what are the problems with the Electoral College as you see it, as it currently operates? Possibly just sign back on to the link. I want to say, just for those who might have had difficulty hearing Bill in his response, he was pointing to one of the biggest problems of the Electoral College are the elements of it that would have the vote for president ultimately wind up in the House of Representatives. And I wanted to ask him more about some of the historical examples of that, because there, as many of you are aware, there have been a number of instances in American history, a few at least, where that's happened. And there was some talk that that would happen again, potentially in the 2020 election. Bill went on to say that one of the challenges, among other things, is just the way the House itself, reflective of the continued divisions in American life and the gerrymandering of districts, has become less and less representative of a body politic and more specifically representative of narrower interests. And the idea that the election for the president would go to that body would exacerbate and complicate the further divisions that already exist in the country. Bill, I don't know if I effectively summarized, but let's try again, see if we can get your sound better. And just log out of the Zoom and click back in. I can also just read a few of the questions that folks have centered, and we can take just a minute to do that. I apologize. We'll stand by for technical difficulties here as we do this. There have been a number of questions that have surfaced about the national popular vote, so I'll be sure to ask more about that. One from Charles Nelson says, at least 20 states with less than average population would have to vote to weaken their political position, saying it would never happen. So agreeing with the assessment that the Bill had mentioned. There's also some questions in the chat just about the degree to which our overall census process and the overall process of apportioning districts is representative, and what does that actually distort downstream as it relates to the Electoral College. One comment from Maddie Pisani, who's a Shriver Fellow and an alum, and great to have Maddie with us, saying the discussion about direct presidential elections seems to reflect other efforts toward more direct representation, like anti-gerrymandering activism, opposition to the power of the Senate due to the disproportionate representation versus population, parentheses, opposition to the filibuster feels like it would fall in this category a bit too.
Are we back?
We are, and you
We
are
are.
crystal clear. Yeah,
Let me cut to the chase, if I may, Steve, because
please.
our time is getting limited. So my solution, which I think is a solution that everyone should support, for the grotesque thought that the House should elect the president in a grotesque way, is at the time the electors meet in their respective states to cast their ballots for president or vice president, at the same time, the chief executive officer who certifies those ballots should also certify the popular vote of that state and send both certificates to Washington to be counted by the House and Senate in joint session, so that in the unlikely event, which has almost never happened, that a candidate for president does not receive an absolute majority of the elector votes, the certificates of the popular vote would be opened, the tellers would count those certificates, and the vice president would declare the winner of the popular vote to be president of the United States. I don't understand why this idea, whose simplicity appeals to me, but apparently to no one else, isn't applauded by everyone.
Well, let me follow up really quickly on that. Why do you think that hasn't been adopted? I mean, in some respects, that seems to go against even the fundamental philosophies behind the Electoral College in the first place, doesn't it? Maybe a practical solution, but it does seem to fly in the face of how the system was structured from the beginning, unless I'm misunderstanding it.
You would have to ask a politician that question and not a mere lawyer towards the end of his career. I don't know the answer to that question. It seems to me that this idea is self-evidently good.
Yeah. Well, let me make sure, just because your microphone and connection was a little spotty, that we get actually to more questions from those of you who are listening. Question from Sophia Johnson. I wonder how changing voting access in prisons and really expanding the enfranchisement would impact the popular vote in the Electoral College. Do you have a sense of those who've been denied the right to vote by the criminal justice system could potentially impact at scale the outcome in any individual area or not?
Well, denial of access to vote is becoming an ever more serious problem. You know, the trend for many years, remember, we started out that only, except in New Jersey, male property owners could vote. And gradually the electorate got expanded to include women. The 13th and 14th and 15th Amendments expanded it to include the slaves. The electorate was expanded to include 18-year-olds. Now the political trend in many states, unfortunately, seems to be to close up the electorate. And that can have a very serious effect on our presidential politics. Most elections for president are not close, either in gross terms or by most states. But some states in every election are awfully close. In the current election, for example, Arizona and Wisconsin were awfully close. My definition of close is to the number of people who vote for candidates other than the candidates of the two parties. If they had voted for the candidates of the two parties, could they have made a difference? That did happen this time around in Arizona and Wisconsin. So yes, in states where the elections are close, the closing down of the electorate can be a serious and negative influence on our democracy.
Reggie asks, if a candidate is elected, the electoral votes have not yet been cast. So between election day and the date at which the electors actually cast their votes and certify their votes, and that candidate becomes unfit for office, what would guide the elector in that instance?
Well, actually, Horace Greeley died during exactly that period. Some of her electors cast their elector votes for Horace Greeley, and rarely does the House choose not to count elector votes, but they choose not to count the votes for a dead person. I think in the situation you describe, some party rules would step in and supply a party candidate in place of the deceased or incapacitated candidate. In other situations where the party rules did not so provide, I think we're back to elector discretion.
Angel Corer says, do you think the Electoral College serves the function today that it was meant to serve when it was created in the Constitutional Convention of 1787? And I'll ask a follow-up first, but what would the drafters of the Constitution think about this mechanism that they designed in practice today?
It was a large state, small state compromise, as were many of the compromises reflected in the Constitution. Some people say that it really derived from the slavery issue. I've read Madison's notes from beginning to end carefully now twice. And in the context of the election of the president and the Electoral College, slavery issue does not surface. I know very well, indeed, about the 3/5 of a person rule in determining the early apportionment. But what many people don't realize is that actually was not an invention of the convention. It was derived from a provision in the Articles of Confederation resolution dealing with the Revolutionary War debt, and simply incorporated by reference in the same provision dealing with the Revolutionary War debt that the convention adopted. There are much worse evidences of the conflict over slavery in our Constitution: the fugitive slave provision, the decision of the framers that they could not prohibit slavery and send a constitution to the states that would get adopted by 9 of them. There are many other compromises that one way or another reflect the economic interests of the South, which of course were based on slavery, as well as the economic interests of the North. I understand that the 3/5 of a person rule is very emotive, but I think the fugitive slave provision, which led directly to Dred Scott against Sanford, which led directly to the Civil War, I think the refusal to prohibit the slave trade until a date far in advance certain, I think these are much more deplorable provisions. And indeed, you can see it in Madison's own behavior. Madison was opposed to slavery. Madison was a proponent of popular election. He lost on both counts. Yet in the Virginia ratification debate against attacks by Patrick Henry on both of those issues, Madison gamely defended the constitutional compromises because he thought that creation of the United States of America was more important, and he was right.
One of the other questions as a follow-up from Angel is, does it seem somewhat odd that a candidate can win the popular vote, but yet lose the presidency, right? Every time where that has occurred, and we've had several instances of it recently in recent history, there's always this popular outcry and a degree of confusion and head scratching for those who don't read their Constitution or their history as carefully as you do. What do you say about that question?
Well, we have to recognize that that rarely happens. It did happen in 1800, but that was before the 12th Amendment. It happened in 1824-25. It happened in 1876-77, where the Congress completely copped out and created a commission to try to resolve the issue, which I'm sure is something they would never repeat. It happened once to Grover Cleveland, who came back roaringly to get himself reelected. It might or might not have happened to Albert Gore in 2000, but I think that's also a very complicated situation. You know, my own personal view, which is not exactly popular, is that my good friend, Albert Gore, son of my even better friend, Albert Gore Sr., should not have conceded. The recount ordered by the Supreme Court, seconded by the Florida Supreme Court, should have continued. And all of the evidence is that if it had continued, Florida would have voted for Gore and Gore would have been elected president.
You also analyzed what might have happened had that election, and I don't want to overlook 2016, which is another in this lineage, but back to 2000, what would have happened had that gone to the House of Representatives? And explain for folks who may not know how it works in the House, what would happen by your analysis.
Thank you, Steve. I tried to create a model of what the House then would have looked like in my article on Senate election of the vice president, House election of the president. And it's quite clear that if neither the younger Bush or the younger Gore had an absolute majority of electors, the House would have voted the younger Bush president, because that was the way the House was stacked. And there's very little question about how that would have come out had it gone into the House.
Many people talked about the possibility of the election in 2020 going to the House of Representatives. How likely did you view that prospect as you were sizing up all of the events leading up to and through, frankly, the November election last year?
I view that very likely because there were no meaningful third-party interveners. We have to remember that Ralph Nader was a very meaningful candidate in 2000, and he probably cost Gore the votes of Florida, Oregon, and New Hampshire, though he continues to deny it to this day. But if you take a look at the election data from those states and assume that most of the Nader votes would have gone to Gore, which I think is the correct assumption, Gore would have won those 3 states and would have won the presidency. In the absence of a meaningful third-party candidacy, it's very unlikely. Possible, but very unlikely. Actually, 538 has a model for the 2020 election, which shows a tie, a 269-269 tie. And the difference between what happened and Nate Cohn's, Nate Silver's, I'm sorry, model is Arizona and Wisconsin.
Samuel Norwich has a question. Assuming that the Electoral College is here to stay, how can we mitigate the caustic legitimacy effects of repeatedly giving a majority in the college to candidates who failed to get a majority in the country's popular vote?
Well, repeatedly is just the wrong adverb. Rarely is the right adverb. It rarely happens, and thank God for that.
Well, you enumerated, what, maybe half a dozen instances? I haven't counted them up. And obviously there was the 2016 election where, the Electoral College obviously went to Donald J. Trump, even though the popular vote went for Secretary Clinton. So doesn't that concern you at some level? Not in specifics, but just in the as a function of our democracy or representative democracy.
It's not a good result for democracy. But remember, the framers rejected popular election of the presidency, and we are stuck with that decision until we amend the Constitution.
Yeah. Let's see here. I've got other questions really quickly that I want to get to, including one, Bill, you'll appreciate. I don't know if you had a chance to hear this, but a question from Madeline Pisani. She says, the discussion about direct presidential elections seems to reflect other efforts toward more direct representation, like anti-gerrymandering activism, opposition to the power of the Senate, due to the disproportionate representation versus population, perhaps opposition to the filibuster falling in that category. Do you see opposition to the Electoral College as part of this larger and seemingly new energy around more direct representation? Or do you see this opposition to the Electoral College as old and long-standing, part of a tradition in American political discourse?
Well, I think the answer to that is both. Certainly, the college is not a democratic institution, and the framers didn't think it would, didn't intend it to be. They intended it as a compromise in view of their inability to resolve the question of whether or not the president should be popularly elected. On the other hand, our history shows that the trend is always toward the expansion of the electorate and to the inclusion, not the exclusion of voters. I have to hope and pray that the current effort to limit the electorate will fail. I have to hope and pray that it is a temporary phenomenon and that the basic trend that has characterized our democracy now for more than 200 years will continue as it should.
Bill, a few questions have surfaced related to just the expansion, both the protection of and expansion of the right to vote and increasing participation, things like establishing Election Day as a national holiday, et cetera, et cetera. What are your thoughts on those kinds of measures, which have been long discussed but have yet to really take root?
Well, I want to get back to Clarence Thomas's concurrence in Chiafalo. Justice Thomas goes out of his way to discuss the original meaning of manner. Initial caps M-A-N-N-E-R. And I have to think to myself, why? And I think the reason why is that there's a provision in the Constitution that gives the Congress authority to determine the time, manner, and places of election of senators and representatives. The only authority that it has ever exercised is to determine the time. It is also true that this provision does not explicitly mention election of the president and vice president. But there are a couple of Supreme Court cases from the late 19th century that create an implied power. I know Clarence Thomas would hate this idea. An implied power in the Congress to provide for presidential elections. And perhaps the time is coming where Congress will exercise this power to establish not only the time and the place, although remember, even in my lifetime, Maine voted in the early fall, giving rise to Roosevelt's famous comment in 1936, as Maine goes, so goes Vermont. But also the manner. And you can imagine that the states, which now control in the District of Columbia in 51 different ways, the manner of electing the president, vice president, senators, and congressmen, would rebel at that thought. Whether such an effort could get through the House today, we are 6 votes divide the parties, I doubt. Could it get through the Senate? No. Should it get through someday? Absolutely. We need a national electoral system that is fair to everyone.
There are a lot of questions pouring in. Let me try to get to the last one or two here before we wrap. One it goes as follows. I haven't heard mention of the word republic in this conversation. Where does that notion, that idea fit within the Electoral College conversation?
It's Madison's actually idea. Madison made it clear on several occasions during the convention and during the debates on the ratification, and maybe even in the Federalist Papers. I can't remember now whether he used that phrase in it, but he said, yes, we were creating a republic and not a popular democracy on the Athenian theme, where everyone met in the agora and declared their votes. We were creating a representative democracy, not a popular democracy.
You have spent much of your life thinking about these questions, perhaps before you were ever asked by the Democratic Party in 1980 to advise on these questions. You've written numerous articles, numerous law articles, popular articles, op-ed pieces. It's not been your core focus of your professional career per se, but it is a passion for you. What is it that you find so fascinating and so interesting about the Electoral College to devote so much time and energy to understanding it and to analyzing it?
That so much is written about it that is wrong one way or another, and misguided and unrealistic. I mean, you take the series of editorials that Jesse Wegman has written on the Electoral College in the New York Times in the course of the 2020 election. They're worthless.
Why worthless?
Because he never, ever mentions the fact that you need a 2/3 vote of the House and a 2/3 vote of the Senate and a 3/4 vote of the states to enact a constitutional amendment to change it. He never mentions that. He never mentions it in those editorials. He never mentions it in his book. This is a member of the New York Times editorial board.
I want to pull the lens out more widely to talk about, as we close, just a different college, and I'm talking about the University of Chicago. As you reflect on your experiences at the college, how has your education there in particular shaped your approach to intellectual and civic life? What impact has it had on
You know, those who are aware of my personal history probably know that I regard the University of Chicago's college as having saved my life. But in addition to that, you know, we had in Soch 1 a wonderful book whose title was The People Shall Judge. It was a collection of seminal writings, Locke, Hobbes, on our society as it has emerged. And of course, I still remember with extraordinary fondness my Soch 1 instructor, Ira Kipnis. It had a major influence on me, and it still does.
Well, Bill, it's always a pleasure to be in your company and to have the chance to correspond and chat and to get the best of your thinking. I miss our chats at the Institute of Politics and appreciate you spending time tonight to go deep with us on the Electoral College. And I want to thank everybody also for sharing their questions as well.
Well, I'm very grateful to Natalia for creating this and to Reggie for getting me to do this, as he appears to be able to do every 4 years. And to you, Steve, it's a pleasure to be with you even virtually, and I hope we'll be together again soon. And I hope we can find a way to do this again, not necessarily on this topic, but on some other.
I look forward to that. Thank you, Bill, and Reggie, back over to you.
Thank you. And I think I just want to make sure I echo all the thanks all around. Let's also not forget Barbara, who was a bit of a lifesaver for us tonight. And I also like to thank the audience for their rigorous participation and keen interest in this topic, as well as everything else. We do try to have great events that rise up to this caliber. We hope to have some more in the future. Please look for notices of events, not only from the New York Club, but as well as the General Alumni Association. I think Natalia might be sending out a survey to get some feedback on how you view this event. But I would just like to say that, as always, Bill and Steve and Barbara and Natalia have delivered. Thank you very much. Have a good night.
Thank you everyone for coming, and we hope to see you again soon, either virtually or in person. Thanks, Steve. Thanks, Bill. Thanks, Barbara. Thanks, Reggie. Bye, everyone.